Welcome back, courtroom fans. Today's case isn't just a legal battle, it's an emotional roller coaster where the stakes couldn't be higher. On one side, we've got plaintiff defense, fighting tooth and nail for justice. On the other, opponent, determined to prove their case beyond doubt. And trust me, what unfolds inside this courtroom will have you glued to the screen. Think shocking testimonies, surprise evidence drops, and a verdict that could leave everyone reeling. Buckle up, because this trial, it's about to get intense.
3 CR 0527, State of Texas versus Sebastian Johnny Castillo. Can I have parties announced for the record for the state?
Jason Garahan, Your Honor.
Defense,
Eric Chirac for the defendant.
are you Sebastian Castillo?
Yes, Your Honor.
All right, you entered a plea on March 30th to count 1, paragraph B, no contest. According to the plea bargaining agreement, punishment is to be assessed at 5 years in the prison. There's an affirmative finding of deadly weapon. State is not making any recommendations to your application. There's an affirmative finding of family violence, and then there's to be no contact with several parties. Did you have a chance to review the PSI report, counsel?
Yes, I did, Your Honor.
State,
Yes.
any objections to the PSI report?
No objection, Your Honor.
All right, the state is silent. So any witnesses, defense?
Your Honor, the witnesses, I just have my defendant.
All right, do you wish to call him?
Yes, ma'am.
All right, can you raise your right hand for me? Do you solemnly swear affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, Your Honor.
You can lower your hand, state your name for the record.
Sebastian Johnny Castillo.
Defense?
Mr. Castillo, do you want a statement you want to make to the court?
I just like to say I'm sorry to my mom, my brothers and sisters.
How old were you when this happened?
I was 17.
Okay, were there some family dynamics going on in this situation with your step parents and your siblings?
Yes, sir.
What was exactly going on? You recall?
I was being beaten and I got kicked out.
I'm sorry, you were being what?
Beaten. No further questions.
All right, who are you saying was beating you?
My stepfather.
And where's the proof of this?
Just his, were any police reports made on this?
No.
Well, did he tell the school?
You tell the school you were getting beaten?
I was kicked out and they went to withdraw me at the school and the cop was there, and whenever they were taking me back home, they kicked me out and I was out for 3 days.
No, my question still has not been answered. So he's saying that his stepfather was beating him at the home.
Mhm.
So did he ever report it to the school? That's either yes or no. All right. So where's the proof? Because what I have is I have him going to a home. I have him where they say that he threatened to shoot up the school. That's why the mother called. And then I have him going back to the home and they're saying that he pointed a gun on them.
Judge, I'm saying here that I think what led to this was they, for some reason, the step parents wanted him out of the situation. He denies that he ever made a threat to shoot up the school. He says that was a false threat. I think they just wanted him out of the house. When this happened, you were actually living with your grandparents. Is that correct?
Yes, sir.
And if you get probation, that's who you would live with?
Sir.
And when this happened, you were what, 17?
Yes, sir.
And do you do any alcohol or drugs?
No, sir.
Now, according to the police report, it says S1 and S2. S1 grabbed a handsaw and you're S1. It says S1 grabbed a handsaw and attempted to saw through the lock to the gun safe. S1 then found a grinder and cut through the lock. S1 and S2 grabbed multiple guns from the safe and gathered them together. The cousins who went with S1 were waiting outside the laundry room with guns in their hands. S1 and S2 also gathered other listed items as well. Victim 3, 4, and 5 were all sitting in the living room sofa.
Wow, did you hear that? That witness testimony just turned the courtroom on its head. Let's break it down. Legally, what was just said could tip the scales dramatically. Here's one relevant legal principle. Such testimony can reshape the jury's perception in an instant. But let's be real. Was this a genuine truth bomb or a carefully crafted move by the attorneys? What do you think? Brilliant strategy or a total backfire? Drop your opinions below.
Judge, at the time of the incident, the defendant was 17 years old. It sounds like it was a family dispute matter. Allegations are of guns being pointed, no shots were fired. It's evident that the parents and stepmother and stepfather do not want him in the location. That's not a problem. He's young. He's got his whole life ahead of him. I think he realizes he made a mistake in that situation. Maybe his anger being removed from the family caused him to kind of have a moment of basically being stupid.
And see, I can understand his position if there were people in the home where this was not their stepfather as well. So this is what the court is going to do. Court is going to find you guilty, sentence you to 5 years in prison, give you credit for any time served. There's an affirmative finding of deadly weapon, an affirmative finding of family violence. There's to be no contact with victim. With regards to the restitution amount, the court does not, they're asking for $45,000 in restitution. The court has nothing before it to suggest that restitution should be $45,000, and no information on restitution has been presented to the court. So the court is not ordering restitution. I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. You won't probably want to go around. Because this is a plea bargaining agreement, because I followed your plea bargaining agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. And because this is an affirmative finding of family violence, and also because this is a conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, Your Honor.
All right, good luck to you. I know we're off the record. I know you're young, and 5 years seems like a lot of time.
Yes.
Time does go by quickly, but you need to start bettering yourself. If there is some type of mental health issue going on, or some other issue that you have, drug issue, or some type of trauma that you've suffered, you can ask for help and they will give it to you. Do you understand?
Yes, Your Honor.
All right, good luck to you. 5795, State of Texas versus John Leal Klosna. Can I have parties announced for the record for the state?
Travis Banks of the State of Texas.
Defense?
Ideli Silver for the defense.
Are you John Leal Klosna?
Yes, ma'am, I am.
Going to show you what's entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision. Did you review that with your attorney?
Yes,
Did you understand it?
Yes, I did, ma'am.
Are you the same John Leal Klosna who was placed on deferred adjudication in 2021 CR 5795 for the offense of assault of a pregnant person on August 31st, 2021 for a term of 5 years? Is that you?
Yes, ma'am.
All right, state.
Violated condition number 7, on or about the 30th day of April 2023 in Wilson County, Texas. The defendant, John Leal Klosna, departed Bexar County without the written permission of the court and or the supervision officer in violation of condition number 7.
How do you plead to that? True or not true?
True, ma'am. The state will waive and abandon the other allegations.
Any objection?
No objection, Your Honor.
Did you understand by pleading true to violation of condition number 7, the court could find it true, find you guilty, sentence you up to 10 years in prison and up to a $10,000 fine?
Yes.
Knowing that, do you still wish to plead true to violation of condition number 7?
Yes.
Court will find violation of condition number 7 true. Is there an agreement?
Yes, Your Honor. The agreement, should the court follow it, is to deny the motion and to alter and amend the conditions to add.
And there it is, the gavel strikes. And Judge Name has just made a ruling that could change everything. Let's unpack this. The decision to ruling details isn't just procedural. It carries major implications under relevant law. The courtroom is split. Some are nodding in agreement. Others look stunned. So here's the million-dollar question. Was this ruling a victory for justice or a devastating blow to the other side? Tell us what you think. Did the judge get it right?
All right, this is what the court will do. Court will deny the motion, alter and amend conditions to include hostility management course, family violence impact course live panel, and 10 days in the Bexar County Jail as a condition. All right, so you're going to go into custody today, serve your 10 days in the Bexar County Jail. And what you need to remember is you have to follow the rules of the court. Do you understand?
Yeah.
All right, so immediately upon your release, you need to get in touch with your probation officer, and you need to remember you're not allowed to leave the county. You understand?
Yes, ma'am, I do.
And you need to remember that the rules of this court are the rules of this court, because this contract is not between your attorney and the state. This contract is with the court. Do you understand?
Yes, ma'am.
All right, good luck to you. 20 CR 10019, State of Texas versus Eric John Orta. Can I have parties announced for the record for the state?
Ruben Herrera for the state.
Eddie Garcia from Mr. Orta, Your Honor.
And are you Mr. Orta?
Yes, ma'am.
Showing you a document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision. Did you review that with your attorney? Did you understand it?
Yes, Your Honor.
Are you the same Eric John Orta who was placed on deferred adjudication in 2020 CR 10019 for the offense of assault of a pregnant person on April 6, 2021 for a term of 2 years and extended for a total of 2 years? Is that you?
Yes, Your Honor.
State?
Your Honor, the state will be proceeding on a violation of condition number 15G in that on or about the 14th day of June 2023 in Bexar County, Texas. The defendant, Eric John Orta, did then and there fail to register for or attend battering intervention prevention program with an approved agency in violation of condition number 15G.
How do you plead to that? True or not true?
Sure.
State?
Look at the emotion spilling over in this room. The closing arguments aren't just summarizing the case, they're tugging at the jury's heartstrings. Here's what stands out. The prosecution framed key point as a moral battle, while the defense hammered on counterpoint. But in the end, it's not about who spoke louder. It's about who told the most convincing story. Viewers, if you were on this jury, who would you believe?
The court is going to grant the motion. The court is going to find you guilty, not grant you community supervision. There's an affirmative finding of family violence. The court will sentence you to 4 years in the prison, give you credit for any time served. There's to be no contact with Jessica Nava, Nava, and state you're dismissing the assault family second and the criminal mischief charges.
Correct, Your Honor.
All right, the court will take in consideration NITMAG number 799937, which is the assault family second, and County Court Cause number 710566, which is the criminal mischief case.
Judge, would you reconsider, based on the violation that he pled to, it seems like the punishment of 2 years would be more appropriate than the 4 years that we were wanting to sentence into. That's the reason that we entered into this agreement, is based on this violation.
All right. All right, the court is going to keep the sentence at 4 years. The court will give him credit for any time served, credit for any inpatient treatment. I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it and did you sign it?
Yes, Your Honor.
All right, you have a limited right to appeal. That right to appeal is as it relates in the allegations in the motion. Counsel. That's that. The limited right to appeal is as it relates to the allegations in the motion, not the fact that you are on deferred adjudication. Do you?
And there you have it. The verdict is in. Judge Name delivers the final decision, bringing this tense courtroom drama to a close. We've seen twists, rulings, and raw emotion from start to finish. This wasn't just about case details. It was about law, strategy, and the human side of justice. So, what's your take? Did the right side win? Let us know in the comments, and if you enjoyed breaking this case down with us, hit that like button, share this video, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.